Good morning all. I declare open this public hearing of the Joint Standing Committee on Treaties and acknowledge that we meet on the lands of the Ngunnawal and Ngambri people and pay our respects to elders past, present and emerging. These are public proceedings, although the committee may agree to a request to have evidence heard in camera or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated as a contempt of Parliament. It's also a contempt to give false or misleading evidence to a committee. In accordance with the committee's resolution of 4 August 2022, this hearing will be recorded and broadcast on the Parliament's website, and the transcripts of proceedings will be published on the Parliament's website. Those here today are advised that filming and recording are permitted during the hearing. I also remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. Transcripts of today's proceedings may not be available in time to meet the deadline for questions on notice. Therefore, could you please keep track of any questions on notice so that you're able to respond in the time required to ensure the committee can meet its reporting deadlines. The committee will now take evidence on the International Labour Organisation Convention number 138, the Convention concerning minimum age for admission to employment. I welcome representatives from the Department of Employment, Workplace Relations and the Department of Foreign Affairs and Trade to give evidence today. For the Hansard record, would you please state your full names and the capacities in which you appear before the committee?
Greg Manning, First Assistant Secretary of the Employment Conditions Division in the Department of Employment and Workplace Relations.
Adrian Breen, Senior Executive Lawyer from the Workplace Relations Legal Division.
Elizabeth DeHoog, Acting Assistant Secretary for the Safety and Compensation Policy Branch.
Jennifer Wettinger, Assistant Secretary of the Economics and International Labour Branch.
Felicity Rowe, Director of International Labour in the Department of Employment and Workplace Relations.
Good morning, Kim Ralston, Department of Foreign Affairs and Trade, Director, International Law Advising, Human Rights and Treaties.
Excellent, thank you. Although the committee doesn't require you to give evidence under oath, I should advise you that this hearing is a legal proceeding for Parliament, therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to questions and discussion.
Thanks, Chair. I have a brief statement, about 3.5 minutes.
Excellent.
So the proposed ratification of International Labour Organisation Minimum Age Convention 138 reflects the government's commitment to ensuring young people in Australia and around the world engage in safe and appropriate employment. The convention requires states parties to set a minimum age for admission to employment of 15 years. It also provides that light work can be engaged in from 13 years. Hazardous work can only be engaged in from 18 years unless certain conditions are present, then the age is reduced to 16 years. And certain categories of employment can be excluded from the convention under Article 4, and there are exemptions for work done in schools or apprenticeships under Article 6 and for the entertainment industry under Article 8. The National Interest Analysis describes how Australia complies with the requirements of Convention 138 based on existing law and practice, and all states and territories consider that they comply with the convention and support its ratification. Domestically, ratification of the convention would reflect Australia's existing strong framework, which prioritises education and safe employment for young people. And internationally, ratification would complete Australia's ratification of all fundamental ILO conventions on forced and child labour, and Australia would join 175 other countries in ratifying this convention. Ratification would support Australia's efforts to take a leading role in the Asia-Pacific to promote stronger measures to prevent and eliminate child labour. It would also strengthen Australia's negotiating position on labour clauses in trade agreements, ensuring Australia can credibly reinforce its commitment to ending child labour and encourage other trade partners to do likewise. Now, Australia's engagement at the ILO is done on a tripartite basis with the Australian Council of Trade Unions and the Australian Chamber of Commerce and Industry, both of whom support ratification of this convention. Turning briefly to Australia's compliance with the Convention, I've already mentioned that the National Interest Analysis describes how Australia complies with the requirements of Convention 138 based on existing law and practice. So ratification of this convention is not intended to impact existing arrangements. So young people would continue to be able to work part-time outside of school hours, and employers would continue to be able to employ young people in accordance with current laws. The key pillars of the frameworks that support the government's decision to seek ratification are as follows. Compulsory schooling laws in each state and territory require children to remain in school or approved education until they finish year 10, which could be around the age of 15, or in most cases until they turn 17 years old. Having a high minimum age for children to leave compulsory education effectively prevents the vast majority of children from being admitted to full-time employment at a young age. Additionally, each state and territory has strong and robust work health and safety laws, which require employers to ensure the work undertaken by young people is safe, having regard to their age and skill levels. There are sector or activity-specific state and territory laws that designate specific prohibitions and limitations on the age of entry for working in certain industries or engaging in certain work activities, and a number of jurisdictions have enacted specific child employment or protection legislation that further regulates child employment. And finally, Australia's social security system ensures children do not regularly need to work to supplement family incomes. So to conclude, we emphasise that the government is progressing ratification on the basis of existing law and practice. Ratifying Convention 138 would demonstrate Australia's commitment to ensuring safe and appropriate employment for young people and addressing child labour globally. Thank you, Chair.
Thank you, Mr Manning. I'll ask a few questions and then go to the Deputy Chair and around the committee. I guess one question that might be in the minds of the broader public is that for where there's been ratification of 175 countries already, it would be unusual, I think, that we find ourselves yet to ratify, where with the United States and New Zealand, I think, as well as a relatively small number of developed countries that haven't ratified. It seems from reading through the material that the reasons for that are partly because there's a well-based sense that we broadly are, or very, very significantly are, in compliance with the requirements of the treaty, but perhaps also some concern that technically, or to the sort of the nth degree of the letter of the law, we might not be. And is it fair to assume that those are the kinds of reasons why it's taken us as long as it has to get to the point of ratification?
I think that it is fair to assume that, in the sense that, of course, priorities of governments ebb and flow and take different approaches to things, and also the attitude of those who might be affected can change over time as well. So there were previous efforts. I think in 2013 it was before a predecessor version of this committee, but then Parliament was prorogued, and it's come back on now. I think also the ILO has, I think it was in the late 1990s, 1998, started a campaign to try and improve the overall compliance with what it sees as the fundamental conventions, and so has kept the spotlight on ratification and encouraging states parties to move towards ratification. So I think a number of those factors have probably played into the timing as well.
It's interesting in a country like Australia that child labour obviously is a terrible scourge, and child labour literally refers to harmful forms of child engagement and work, which is not hard to imagine. But statistically, from some of the material, again, that we're provided, in Australia, it's actually children from higher socioeconomic parts of the community that are more likely to work than children from lower socioeconomic areas, while even though kids from lower socioeconomic backgrounds, where they do work longer hours, you wouldn't find that, I think, in developing countries where there would be different kinds of pressures. We wouldn't assume, and we can't assume, that child labour, the harmful engagement of children in work, doesn't exist in Australia. So I'm just interested in, does the government or your department have any developed sense of the extent to which it does occur? Do we measure it? Do we look at it periodically?
It was certainly ratification of this treaty is a commitment in the National Action Plan to combat modern slavery for Action Plan covers 2021 to 2025, which goes to, I suppose, a level of concern about the practice generally and the need to make sure that Australia's, complying with complying with relevant international treaties. But I'll hand off to my colleague to see if we've got any data on the extent of it, Chair.
Thanks, Mr Manning. Thank you, Chair. So, as my colleagues outlined, it is, I think the fact that we're ratifying on the basis of the fact that Australia's laws and practices are already in compliance shows that within the letter of the Convention, within Australia, any form of child labour that contravenes this Convention is unlawful. What I can tell you, though, is that currently there are an estimated 214,500 children in Australia that are less than 15 years old and that worked at some time in the last 12 months, and that's based on June 2022 statistics, with a further 367,100 15 to 17-year-olds that were employed the week of the survey in August 2022. However, I guess to contextualise that, and within the spirit of the Convention, children working is actually seen, within our society as being an excellent development opportunity and an ability to, get a work ethic, etc. So those statistics don't necessarily highlight unlawfulness per se, just children engaging in work activities. It would be difficult, and I don't have the statistics in terms of, our criminal jurisdiction and what's certainly being penalised and what's being seen by the authorities, such as the Fair Work Ombudsman and, of course, our police and legal system that would, of course, be involved in penalising forced and child labour in the sense that it's illegal. But any child labour that contravenes this convention, importantly, is illegal in Australia.
I mean, yes. So I think the fact is we have structures in place that make child labour unlawful, like the harmful engagement and improper engagement of children in labour unlawful. And we know that it occurs. It must occur to a small degree at least. So you're saying that to the extent that we're aware of the problem, we consider whether our measures, because one thing we have a law that says this shall not occur. It's a separate question as to whether you've got the frameworks in place to make sure that it isn't occurring, or where that it does occur there are legal consequences. You mentioned the Fair Work Commission. I assume that because most of the legislation is state-based legislation, there must be state-based bodies that are responsible for looking at this and responding where there seems to be some evidence of child labour. I'm just interested in how that's monitored, whether it's ever aggregated on a national basis, and we can therefore say, from year to year, incidences of child labour is staying level at a very small level or a low level, or it's increasing slightly, or it's decreasing, anything like that.
Yeah, and I think those statistics Ms. Wedding were outlining, formal employment, if you like, so legal employment where children are working in a way that would be consistent with the convention. Not aware of there being an amalgamation of all of the numbers of contraventions of the various laws that would be relevant in this space, but we will take on notice and inquire into that. But I don't think that there is, and that it goes to the issue you raised earlier about how does Australia comply, because this is a situation where, as set out in the national interest analysis, there's not one neat prohibition saying this cannot occur. Although, as you touched on, in every area of regulated public life where there is such a thing, there is still a problem. Hence, we have regulators who have to follow it up. But rather, the view of the states and territories and the Commonwealth is that the requirement to be in school, and there are some exceptions to that, but those exceptions require approval to be granted by relevant authorities who acting according to certain criteria, together with work health and safety laws, which go to requiring a safe workplace dependent upon the circumstances of the case and the age and vulnerability of the people involved, as well as other factors which would go to up to prohibitions on certain types of conduct behaving mean that overall Australia can say it's compliant. But as you've indicated, it's not to say there wouldn't be instances of non-compliance like there is with every area of regulated life. And we'll inquire as to whether that's amalgamated. As I said, I don't think it is.
Yeah, I'd be interested. I mean, if it's possible, if you to take on notice just what data there is. I think one of the things for Australia to be mindful of, and we saw this a little bit through the modern slavery, is that as we've been advised, we're ratifying a treaty where the assessment is that actually, from a regulatory point of view, we don't need to take any further action. There's a little bit of a danger in those circumstances that you don't turn your mind to the spirit of the convention, what ratification means, as opposed to the sort of the letter of the law, because in any of these areas, it's about the quality and the effectiveness of the regulation. You do want that to be considered in a dynamic way. I mean, things should be getting better, and we should be looking for that to be the case, but it's always possible for things to get worse.
And the treaty does acknowledge that in the sense that if Australia was to become a party, then 12 months after ratification, it would be required to lodge a report on its compliance, and then there is a committee of experts regime which would provide comment on how they see Australia's compliance, and that is primarily there to establish the type of dialogue that you're talking about at the international plane.
Yeah. And that's not a bad thing. Sometimes that's good. You make a commitment, then you're held to that commitment. You have a good look at. I mean, I know that one of the categories is around hazardous work, the minimum age, and the way in which it is or isn't defined, and what it might encompass. And if you go through the table, it has all of the different state approaches. That's probably the one column where it seems that there could be some more detail around the minimum age and the circumstances in which, or the kinds of work that might be legitimately undertaken or ought to be ruled out, which is not to say that they're happening. I mean, I guess we don't know. I will leave it at that and go to the Deputy Chair.
Thank you. Thank you all for attending today. I have a couple of questions. On page 16, it talks about minimum age being not less than 15 years. I left school younger than that and did a traineeship in concrete. I'm only 34. It's not like I'm from a different generation or anything. School wasn't for me, but I did have to do schooling later because I joined the military. But my question is there like a waiver or something that could be in place or is in place for young people that leave school before 15? Because you can't say there's not. Townsville, there's plenty. And stopping someone getting an apprenticeship or something like that could be detrimental to their future. Because people who have long time with no employment, no schooling and no employment, then become less likely or harder to get into employment. So
there's two factors that are relevant to it. The first one, which I'll get my colleague to speak to, is Article 6, which has some exemptions from the convention in relation to things like formal apprenticeships, for example. And then the other factor I touched on earlier, which there is in the legislation about minimum school age or your minimum leaving age, there is a ability in most jurisdictions, with the approval of a parent and the relevant education authority, for children to leave earlier than the minimum age. That normally, we're told by jurisdictions, happens in the case of illness or health reasons, but can happen for other reasons as well. And I touched on earlier, there are normally criteria, like in the ACT, for example, it's the education authority can make the decision if they think it's in the best interest of the child overall. But I might get my colleague to talk about how the convention deals with apprenticeships.
Yeah, certainly. So thank you, Mr. Manning. So I think, importantly, as Mr. Manning's outlined, there is an exemption within Article 6 that, in terms of the minimum age, it does not apply to work in schools and apprenticeships. And there are certainly state and territory education and training legislation permits, which allow children to engage in, apprenticeships and traineeships, which won't impact on our compliance with the convention. And I think what's also important to point out is that it's not, the convention doesn't impose a a sort of a blanket number. So we will be, in ratifying this convention, you do need to specify a minimum age, and as you've correctly identified, that will be 15 years of age. But within the convention, there are a number of flexibilities, so not only in terms of apprenticeships and traineeships, but also in terms of, say, light work, for example, and that's ages 13 to 15. Light work is certainly allowed under Article 7 of the Convention. And also in terms of hazardous work, which is seen as obviously the most important one to regulate, particularly in terms of children's morals and also in terms of their health. The age that's permitted there is age 18. However, within the convention, there is Article 3 allows for certain exemptions for 16 to 18-year-olds where there's appropriate training and occupational health and safety in place. And Australia will be relying on that exemption because obviously, and my colleague can talk about our exceptional and world-class workplace health and safety laws, which will allow us to rightfully use that exemption. And then just finally, there are other exemptions in Article 4, which allow children under the age of 13 in certain circumstances, which we've identified and touched on a little bit earlier, which are light work, but allow children to gain certain certain other skills. So things like paper deliveries, work in a family business, work in a school sort of tuck shop or at a sporting field, and those are sorts of things that we'll also be exempting. So I think probably a very long way of answering your question about your own personal circumstances, that there are a lot of different circumstances, and the convention does have a lot of flexibility that we can rely on.
Yeah, good. It was more to clear it up for me, and I believe that all young people should spend as much time on their education as possible, but some people don't fit into the round hole like myself. So, and hazardous work. I'm assuming that the military would be covered in hazardous work, and you can join that at 17. You don't have to join at 18. I do think that and we are supportive. I'm definitely supportive of this, and I think you've done a fair bit of work in getting here. I suppose this doesn't happen quickly and takes quite some time to do. And I think that there are many people around the country that would be listening, going, okay, what does this mean for me? And not everyone's going to finish school, and they're going to be looking for work, and I think they'll be looking closely at how this affects them. Thank you.
Thanks to your chair. Ms Chesters.
Thank you. I have to confess, when I read the meeting papers, I did have a little moment of, oh my God, I can't believe we haven't ratified this. It was a real sort of reality check, particularly given I've had the opportunity since being a member to go to countries like Myanmar, Cambodia, Vietnam, and have conversations about this issue. So I guess my first question is, us ratifying this, how does that help us internationally in our region, help provide leadership? Because, in our meeting papers, we know the states are already there. Federally, we are already complying. How will this help us with countries who may have ratified but struggling to really implement the changes? Like, you're on the ground for 5 minutes in Myanmar, Cambodia, Vietnam, you see it is a problem. So how will this help us with our relationships in our region?
Yeah, thank you. I think that it will put us on really solid ground to take a strong leadership role. You've mentioned Myanmar, obviously, in our region. I'll start by talking internationally. And of course, approaching universal ratification, I think at the International Labour Organisation, it will boost our already high profile and high standing at the ILO by ratifying, what is essentially a fundamental convention and is near ratification. So it will increase our standing at the ILO. And of course, you'll be aware with the Sustainable Development Goals coming into place in 2015 and certainly Sustainable Development Goal 8.7 being around eliminating child labour by 2025. Again, that will put us in a position where we are going to be showing our real leadership at that international level. Importantly, regionally, and this is touching on your point as well, what we do know is that 30% of child labour exists in the Asia Pacific region. And, I think Australia is an excellent leader within our region, and, with us ratifying this, it will also provide us with the gravitas to be able to encourage others to ratify. Of the remaining countries that are yet to ratify the convention, I think it's 8 in our region that have not ratified. So we're talking about near universal, and our region is the worst. So Australia really can show a really strong leadership role in this regard. We do, obviously, we're permanent co-chairs of the Bali process, and, talking this morning to the Ambassador for People Smuggling and Human Trafficking, and certainly her view was that this would really help in our call to our neighbours to enable them to ratify, and not only ratify but to actually implement action, because obviously that is the next. That's the next sort of piece of the puzzle. It's sort of sometimes easy to ratify, but implementation and monitoring is where the rubber hits the road, so to speak. So it would absolutely help in that regard. And also Australia plays a really strong role in our region in terms of development cooperation. So, we can certainly then use this as a launching pad to go and, working with our colleagues in the Asia Pacific region to help boost their labour standards, and, the 48.7 million children in our region that are currently in child labour. Thank you.
Thank you. I'm going to go to Mr. Burrell and then Mr. Burnell.
Thank you. I'm just interested in your analysis of when our ideals and ratification treaties such as this run into some of our other aspirations as a country. And I want to give you an example that was reported in the media on the weekend and did some commentary about the use of child labour in renewable energy and in some of the precious metals and energies that are mined in Africa that we need to achieve our goal that all of us share about reducing our greenhouse gas emissions. Now, it was Claire Lehman writing in Australia who talked about some Australian companies shipping solar panels to West Africa, and the claim is that when the e-waste lands in a dump in Ghana, children rip apart solar panels to extract small traces of precious metals, exposing themselves to toxic levels of lead. And also she talked about the Washington Post drawing attention to the fact that children in the Congo are digging out cobalt with their bare hands. Now, we have an aspiration to use a lot of this material, recycled renewable energy, work towards reducing our greenhouse gas emissions. But it does run into some of these principled issues that we have, that we don't want to see this happening now. Even if some of these countries aren't ratifying this treaty, I'm just interested in your analysis of where Australia's obligations with child labour meet with some of the other things we're trying to achieve in terms of clean energy.
I mean, the words of the treaty itself are about entry into employment in Australia rather than, for example, an international supply chain. But I think it more goes to the point Ms Wedding was just raising about the credibility we have when we might seek to address it in other countries, in the sense that if we're saying, well, we're prepared to be bound by the same obligations and we're prepared to engage in the dialogue with the ILO, so hence you should be as well. You obviously come from a much greater position of strength when you're asking of others things you're prepared to do yourself. But in relation to the treaty obligations themselves, the circumstance you were describing where a company had sold something into another country and it was there that the treaty wasn't being complied with, that wouldn't put Australia in breach of its obligations, but rather goes to that broader point about our efforts to end these practices globally.
it would be the case that some of what we have committed to and then sought to implement domestically with respect to modern slavery might pick up some of the things that Mr Burrell is concerned about.
Yeah, that's
Australian.
other sort of processes or initiatives where we're seeking to have more transparency in the supply chain that would be relevant, but they're not. There's no greater obligations imposed by Australia becoming a party to this treaty in relation to those things. If that makes sense, yeah. So it doesn't prevent them, but it doesn't require anything that's not occurring now.
Absolutely. So just to add to what Mr Manning has just outlined there, obviously we have our own Modern Slavery Act 2018, which is currently under review, which of course looks at supply chain issues. But one really important point when you're talking about trade is that increasingly, certainly the fundamental ILO conventions, of which, as we've outlined, the Minimum Age Convention is one of those, is a requirement. Ratification is a requirement. So, for example, the EU FTA ratification of this convention is a requirement. So increasingly within trade, having high labour standards is seen as a really important benchmark to allow us to engage in trade with those partners.
Thank you. Thank you, Mr Burrell. Mr Burnell?
Thank you, Chair. Thank you for coming along today. My question goes back in line with the Deputy Chair's line of questioning around the Article 3.3 in relation to exemptions to hazardous work and the age limits. What type of jobs would be exempt under that article?
Well, this, thanks very much for the question. This would relate to a range of types of work which could be perceived as giving rise to some sort of risks. The Article 3.3 application relates to the ways in which work health and safety laws talk about training and appropriate supervision and those sorts of things. So for types of work that are able to be done where the risks are able to be properly mitigated, that's more or less what Article 3.3 is talking about. What it doesn't include, for example, would be areas of work where performance of work by someone under the age of 18 is prohibited. So there's various laws in the states and territories relating to, I don't know, working in casinos or firearms or explosives, those sorts of things that couldn't be caught by 3.3. But where the risk, where the work is able to be done by a person who's under the age of 18 and work health safety and other sort of measures are able to be put into place, that's how that would work. And that could be anything, for example, working in a sort of a fast food environment and dealing with cooking chips and that sort of stuff. That there's trainings provided, appropriate supervision, and that's all squared away, having regard to those work health safety laws primarily.
I have one more question. It's in relation to the minimum age. So under the ratification process, the minimum age would be 15. But when you look at this chart, it's a very disproportionate age bracket for what minimum age is. So looking at this, Victoria's got 13, some 15. What is the implication around compliance for the states and territories, and how much work would need to be done to sit within the framework of this document if it's ratified?
So certainly the states and territories have indicated that they are compliant. So what you're looking at there, where 13-year-olds, etc., are able to work, as I've outlined, Article 7 does allow light work for 13 to 15-year-olds. And in addition, we will be utilising the Article 4 exemptions for work that is, considered, as I said, within the values and norms and doesn't harm the education of children, such as, paper delivery, etc.
Okay. Thank you. That's all from me, Chair.
Thank you. Mr Molino? Dr Molino, I should say.
Look, one very quick question, and it really just follows up on some of the questions that Ms Chesters was arguing around leadership, and I suppose it's the other side of the coin. I mean, I think you explored the fact that ratification allows us to play more of a leadership role, but I suppose it also strikes me that, where you've got 175 countries having ratified, where we claim that we are compliant. Non-ratification, in a sense, I mean, you talked earlier about the ebbs and flows. I mean, the flip side of it also is that continued non-ratification makes it look like it's either not important, or you could argue it sends mixed signals in a sense. Like, if you're compliant, why not submit yourself to the transparency regime? So I suppose, you know, in a sense, this will enable us to remove us going into discussions around this internationally without a hand tied behind our back, in a sense. Do you think that's one of the positives of ratification?
Definitely. I mean, one of the advantages is that where we're saying we would like to project our own high standards to others and seek for them to, you know, raise their standards, then at least signing up to the convention that sets out the minimum standards in this regard gives you some more credibility in those sort of situations. Likewise, if you're engaging in negotiations on trade agreements and you're talking about labour standards, then showing that you subscribe to what the ILO has said is one of the fundamental conventions, again, puts you in a more credible position when you're asking others to do that. And we touched on earlier in relation to the oversight mechanism as well, and showing that you're prepared to have those conversations and think about it and learn as you go along allows you to, you know, more credibly ask that of people who are perhaps not as clear in their compliance or their own high standards.
Yeah, great. Yeah. Thanks.
Committee members, any further questions? No. Okay, look, the last thing I just ask is if the report that was referred to earlier, that once we ratify, there's a 12-month report that gets lodged. If you wouldn't mind just taking on notice, I think it would be, if it's possible, it would be good if that was provided at the time to the committee, just for our interest. I mean, I think sometimes where there are those reports, particularly in the early aftermath of something that we've ratified, it's not a bad thing for the JSCOT to be able to have reference to it and align what actually seems to be the case at that point with what we were told was the case at the beginning. So
we'll do, and we've got more immediately that data inquiry we'll look into as well.
Yeah, no, I appreciate that. But thank you all for your attendance here today. As we've just discussed, please provide additional information to the Secretary within 7 working days. As I said at the beginning, witnesses are responsible for meeting the deadline in a timely manner. You will know about that. You will be sent a copy of the transcript of your evidence when it becomes available, and have the opportunity to request corrections to transcription errors. But again, thank you all, and I declare this public hearing closed.